3. Administrative requirements for the rule, Executive Order 12866. The final rule of the revision, Title 29 CFR Part 29, is significant regulatory action under Statute 3.5 of the Executive Order 12866 because it raises no novel legal and policy issue, rising legal mandate for the President and priorities. The principle and set forth the executive order accordingly pursuant to the executive order. It was reviewed in the Office of Management and Budget Revision, Title 29 CFR Part 29, pertaining to the terms and conditions of the apprenticeship of the program, sponsored the registered program, standards of apprenticeship for the federal purpose of the department with a grant authority for the state registration agency with the act on the behalf of the department registered apprenticeship for the program, standing for the federal programs. Federal purpose of benefits of recognition for the apprenticeship program and federal purpose are to meet the requirements of the federal contract. Grant agreement, the range agreement dealing with the apprenticeship, the requirement of any for the federal financial and other assistance benefit, the privilege, contribution aligned with exemption, preference for the right to pertain with the apprenticeship. The sense the final rule is the first provision of the regulation for the national apprenticeship system since the department of the first promulgated with the rule 1977 the raised the novel policy of the issue that the department has determined the cost of the program to sponsor state registration agencies associated with the registration apprenticeship program and the apprenticeship under the revised terms. Any condition only minimal with different from the other pertaining with the current requirements of the current 29 CFR Part 29, but the revision will not have an annual effect on the economy of $100 million or more. Will they adversely affect the economy, the sector of the economic productive, the competition, job, environmental, public health, and safety, state, local, and tribal government community in any material way? Therefore, we conclude the final rule is not economically significant. It is not subject to the Statute 6A3C of the Executive Order, the Paperwork Reduction Act. The final rule requires the registered apprenticeship program sponsored with the apprenticeship to submit the apprenticeship agreement with the perform with the Department of Labor with the appropriate state registration agency. These requirements were previously reviewed with approved by the use of the Office of Management and Budget under Title 29 U.S. Standard Code 50 and Title 29 CFR 29.1 and as signed with the Office of Management and Budget Control Number 12050223 under the provisions of the Paperwork Reduction Act of 1995, Title 44 U.S. Standard Code 3501. PRA or Paperwork Reduction Act. Additionally, Office of Management Budget previously approved with the Department of the Information Collection and request for the apprenticeship agreement with the Statute 29.7, including the collection with the apprenticeship Social Security number, Office of Management and Budget Control number 12050223, expiration date October 31st, 2008. The Department is in the process of obtaining the extension of the form for 3 additional years. The Department has determined that the final rule contains no information collection requirements, nor that any of the requirements are substantive or material modified by the changes contained herein. Executive Order 13.13.2, Federalism. The Department has reviewed the final rule in accordance with the Executive Order 13.13.2, determined that it is a federal implication because of the substantial directive effect of the state with the relationship between the national government and the state that is noted with the NPRM. The Department has devised the proposed rule made based on the advice of the Advisory Committee of the Apprenticeship Advisory Committee on Apprenticeship and a consultant with the State Apprenticeship with this agency, National Association, State and the Territorial Apprenticeship Directors. The organization representing the apprenticeship of the official with the District of Columbia with the 27th to 3 territory of the apprenticeship advisory committee with the apprenticeship with the states representing the 2 association state labor and apprenticeship officials, including the National Association of State Territorial Apprenticeship Directors, offered and specified the suggestion and on matters relating to the apprenticeship. Program standard registration, deregistration, apprenticeship of the program proposed rule with incorporated with the accredited advisory committee on apprenticeship recommendations discussed above. The comments regulatory change, but the final rule carries forward these recommendations. The National Association of State Territorial Apprenticeship Directors and State Apprenticeship Agencies do not have direct input into the development of the section proposed final rule with directly affected the state of the relationship between the national government and the state. The department gave through the consideration National Association of State Territorial Association of Directors, or National Association of State Territorial Apprenticeship Directors, recommendation on existing regulations submitted in the letter for the President of the National Association of State and Territorial Apprenticeship Directors in December 2006. There was a response request for the Office of Apprenticeship, National Association of State and Territorial Apprenticeship Directors. Recommendation for the proposed rule pertain to the rules of the State Apprenticeship Council with the State Apprenticeship Agency's composition with the State Apprenticeship Council's requirement of the reciprocal approval of the programs registered in one state as seeking the recognition of another state, and the final rule effective with the recognition state of status currently recognized with the State Registration Agency with the name of the Department of Labor and even the responsible oversight of the National Apprenticeship System. As stated within the end notice per NPMR, the discussed further below the conservative input of the adopted the National Association of State Territorial Apprenticeship Director with recommendations developing the proposed final rule addition with an overview of the comments submitted by the National Association of State Territorial Apprenticeship Directors and State proposed the rules identified 6 areas of concern with the state, some of which consistent with the National Association of State and Territorial Apprenticeship Director recommendation revision for the area of the increased administrative burden for the state, impact of state internal organization structure, requirement for linkage within the workforce investment proposal system, expansion of reciprocal approval for the program standard for the building of the construction industry of the Department of Revenue State principal laws, regulation, policy, procedure, recognition state of the status of the currently recognized state registration agency when where appropriately feasible for the effective function with the federal state partnership for the registered apprenticeship for the federal purpose. We revised the final rules to ease the administrative burden within the state. Further, the other issues pertaining to the federal state partnership to determine the proposed requirements for the final rules necessary to ensure conformity with federal law consistent with the across the national apprenticeship system as noted with the NPRM. This discussion above the final rules affect internal state organizational structure with regard to the state apprenticeship agency, state apprenticeship council. Although no changes have been made to the final regarding limiting recognition to the state apprenticeship agency. We'll have set forth explanation for the requirement. We have determined that because of the direct relations between the federal and state agencies necessary for the smooth functioning of the national apprenticeship system, the department will only grant the recognition for the state apprenticeship agency to act as the registration agency for the proposed registered apprenticeship for the federal purposes. The final rule requires the recognized state with established continue the use of the state apprenticeship council, which may serve either advisory and regulatory role. Accordingly, complying with the final rule may require the state seeking the recognition of the registration agency to modify the internal organization structure pertaining to the state apprenticeship agency and the state apprenticeship council re-recognize. The National Apprenticeship Act of the Workforce Investment Act do not authorize the department to mandate the state workforce investment system and economic development strategies, including registered apprenticeship through all the department, encourage the integration with the state apprenticeship agency, may seek such integration through the authority of the internal state organization issuing the remains with the state. Therefore, the final rule simply requires the state apprenticeship agency seeking recognition to demonstrate how it pursues linkage and coordinate with the state publicly funded workforce investment system economic development strategies as discussed in the NPRM, as through the increased coordinated state apprenticeship agency and can promote the registered apprenticeship to a broader audience, further expand the apprenticeship into the high growth, high demand occupations. The NPRM also noted the proposed extension requirement for the reciprocal approval of the program's building construction industry with the requirement that the other state may also raise question regarding which state registration requirements would apply. As discussed above, the final clarify the rule clarify the program sponsor seeking reciprocal approval from the host state must meet the host state wages and hours provision of the apprenticeship ratio standard. Therefore, the state registration agency retains the authority to enforce the wage and hour provision of the apprenticeship ratio standard in the respective state labor law. The commenters asserted that the requirement for the Office of Apprenticeship Review and approval of the proposed modification to the state apprenticeship legislation, regulation, policy, and procedure prior to the implementation observed for the state authority. Final rule clarified with the National Apprenticeship Act and broad mandate of the Department to safeguard the welfare of apprenticeship, provide the Department the authority to ensure recognized state apprenticeship agency remains accountable for the conformity of the federal law. However, we recognize the state has sovereign power with authority to establish the state of the law policy balance in the interest of these two authorities. The state authority to promulgate the state law and policy of the department authority to ensure the recognized state remains accountable for the conformity with the federal law. The final rule provides the Office of Apprenticeship concerns with the proposed modifications to state apprenticeship legislation, regulation, policy, and procedure for the federal purpose of provision with the review of the concurrence intended to provide the responsibility opportunity for the Department to inform the recognized state of the area of the non-conformity provisions that are not intended to diminish the restriction of the state authority to establish law policy, state decision to establish state law with the policy that does conform with the requirements of the federal apprenticeship law. Regulation has consequences which may include the de-recognition of the state apprenticeship agency as the registration agency authorized to register apprenticeship programs standard for the federal purpose. However, such recognition does not affect the state authority to register apprenticeship programs standard for the state purpose. We also have the same for the time frame of the state seeking new and continued recognition of registration agency to submit the documentation specified in Statute 2913A. The NPRM provided with 1 year of the effective date with the final rule. The final rule provided for 2 years from the effective date of the final rule recognition of the burdens associated with the transition period. Finally, we reiterate the final rule pertains to registered apprenticeship for Federal purposes with existing regulation, but the final rule remains silent with the matter of the pertaining to the state registration oversight of the apprenticeship program and the apprenticeship of the state and local purposes. The distinction between the registered apprenticeship of the federal purpose and the registered apprenticeship of the state and local purposes serve with the limit to the scope of the federal government role in the state government functions. Unfunded mandate of the Reformed Act of 1995. The regulatory action has been reviewed in accordance with the Uniform Unfunded Mandates Reform Act of 1995, Title 2, U.S. Standard Code 1531, Executive Order 1287.5. The Department has determined that the rule does not include any of the federal mandate, but the result of increase of expenditure of state, local, tribal governments, and aggregated or by the private sector of $100 million or more in any 1 year, adjusted by the rate of the inflation between 1995 to 2008, $130 million. According to the department, it has not included a budgetary impact estimate. Assessment of federal regulation policies and family. The department certified that the final rule has been assessed with according with the statute 654 of the Public Law 105-277 of the statutes 112-2681 with the effect of the family well-being. With the department concluded that the rule will not adversely affect the well-being with the nation's family. Rather, it should have the positive effect for the safeguarding wealth and welfare and registered apprenticeship. The Regulatory Flexibility Act and Small Business Regulatory Enforcement Act, Fairness Act of 1996. The department has notified the chief of the Council of Advocacy of the Small Business Administrative made with certain pursuant with the request for with the Regulatory Flexibility Act of Title 5 U.S. Standard Code 605B. With the final rule will not have a significant economic impact with a substantial number of the small entities under the EFA request for Regulatory Flexibility Act with no regulatory flexibility analysis required where the rule will not have significant economic impact with a substantial number of the small entities. The small entity is defined with a small business, small nonprofit organization, small governmental jurisdiction, Title 5 U.S. Standard Code 60135. The definition for the term small entity does not include the states of the individual rules. Revised the upstate the procedure for the labor to pertain with the registered apprenticeship program administered by the state and the department, not by a small governmental jurisdiction. That are approximately 250,000 separate employers that participate in roughly 29,000 registered apprenticeship programs. There are an estimated 468,000 apprenticeships within the National Apprenticeship Certificate. Although there may be substantial the number of the small business impact of the rule, most of the 250,000 employers of the department does not believe that there will be significant economic impact with these entities. The small business will not occur. Additional increment of the cost of the requirement rulemaking because of the aspect of the rule most likely to impact the small entity. The program oversight with the primarily applied with the registration and to monitor the registered apprenticeship program rather than imposing the requirements of the registered apprenticeship program. For example, the Title 29.5 here for the forward current program oversight with the requirement for programs masters comply with the Title 29 CFR Part 30 for the equal opportunity for the opportunity regulation with include the compliance with the review conducted with the registration agency. Title 29 for the imposed with the regulate registration agency and the new regulatory requirement to perform the quality assurance of assessment registered apprenticeship program as part of the agency performance accountability responsibility with the new provision the Title 29 requirement to perform quality assurance assessment long-standing of the pursuant circular 9202. The Office of Apprenticeship Guidance on Quality and Assurance Assessment Assignment is issued in 1991. Registration agency have assessed the apprenticeship program performances, identify the areas of the strength and opportunity for improvement. Final rule provision equal opportunity compliant with the review of the quality assurance assessment is no assessment responsibility of small programs. Other programs compliance with the cost of program sponsors associated with the program oversight will be the same as under the current regulations. However, through the comments of the NPRM, there has come to the attention that the program performance provision in 29.6 may be placed unintended burden with the small apprenticeship program responsible for the small business by the potential increase with the cost of maintaining the conformity with the part of the potential leading with the degree registration of the small apprenticeship program. Particularly, we are aware of the concern with the requirements of Statute 29.6c with the registration agency evaluate the program performance comparing with the completion with the rates of the program in like industries. Occupations in geographical areas with the possibility of unfairly penalized for the programs operated with a small business. We are also aware of the concern with the proposed in 29.6a with the requirement of every program that must have at least one registered apprenticeship that could unfairly impact small apprenticeship programs that may experience short periods of the time out without any apprenticeship to avoid such intended consequences. For the department have made changes to these provisions in the final rule discussion below. As discussed above, the definition 29.2 for the program performance standards of 29.6 for the program deregistration 29.8 The department clarified the relevant provision final rule to address the concern about the compliance cost of the burden on the small entity of the potential associated with the registration agency evaluation program performance in statute 296A. The NPRM provided at least every program must have at least one registered apprenticeship in order to be designated as a retaining designation as a registered apprenticeship program for federal purposes. We pursue that there may be a limited time that the sponsor may have a lag between the training cycle to meet without registered apprenticeship for a short period of time. We recognize that the small programs with fewer apprenticeships may encounter such a situation more frequently than larger programs. Therefore, the final rule established a 1-year time frame during which the program sponsor may be without registered apprenticeship, so the normal program cycle will not lead to deregistration of the small apprenticeship program. By providing a period of up to 1 year, so that the rule will not be effective to small programs that are without apprenticeship during the period training cycle of the revised statute 296A, with reduce the administrative cost burdens associated with the small program. Sponsors potentially having re-registered their program, they could have otherwise be canceled in conformity with the Pro 269A. We have revised 296A with address the potential concern with the requirement that the registration agency evaluate the program performance comparing with the completion rate of the program in like industry, occupation, geographical area with the negatively impact of the small apprenticeship programs. If the registration agency with the comparison of the completion rate would unfairly penalize the program operated by small business to address the concern with the minimum of any potential unfair impact with the performance accountability provision on small apprenticeship. Programs final 29 with the remove the comparison with the completion rates across the geographical areas, industrial occupation drop with the reference of the period with the pros in 2960. Registration agency take other appropriate action against the such programs to provide validation of the performance registered apprenticeship program based on the comparison of the national average of the completion rate. The preamble discussion of the provision clearly explains the completion rate with the information intended for the registration agency you've identified with the program that may benefit the technical assistance will not automatically lead to the program deregistration. The final rule clarified that the completion rates may be potentially factored with the deregistration procedure only when the program demonstrates an outgoing pattern of very low completion rates over several years. The function of the calculating completion rates and the provision technical assistance by the discussion way to improve the program completion rates effectively being the part of the registration agency oversight of the operation of the requirements will not agree that the new compliant with the cost of the program sponsor. The change made in the rule minimize the burdens on the program sponsor, the small entity, with eliminating the risk for the unnecessary program deregistration proceedings that may have been possibly under proposed in 296C. The additional definition for the quality assurance assessment completion rate with the D definition final 29.2 with the clarification of the version of the program performance entitled statute 29.6. Program deregistration final 29.8 with the final rule minimize the compliance with the cost reduced any potential burden on small entity that may have the result of from the NPRM. Therefore, the department certified that the proposed rule will not have significant impact on the substantial number of the small entities as a result. No regulatory flexibility analysis is required. As discussed above with regard to the program performance standard with the final 29.6 with one of the commenters sure the impact of the provision evaluation of the apprenticeship program qualifies as a rule as a major rule under the Executive Order 12866 or the SBREFAA. The department disagreed with the note above provision of the evaluation program performance necessary to ensure the program quality, accountability, and the national apprenticeship system do not represent into the establishment bid requirements of state and local construction prior. Therefore, the department could certify that the final rule is not a major rule defined in Statute 804 of the SBREFA, Title 5 U.S. Senate Code 804. Executive Order 1317.5 of the Consultation coordinated with the Indian Tribal Government. The department has reviewed the final accordance with the Executive Order 1317.5 that determined that it does not have tribal implications, that proposed rules does not have substantial direct efforts on one or more of the Indian tribes or on the relationship between the federal government and Indian tribes on the distribution of power and responsibility between the federal government and Indian tribes. Executive Order 12.988, Civil Justice. The final rule has drafted the reviewed according with the Executive Order 12.988. Civil justice reform will not unduly burden the federal court system. The rule has been written so that it minimizes litigation provided with this clear legal standard of effective conduct, has reviewed carefully to eliminate drafting errors and ambiguities. Plain language. The department drafted its final rule in the plain language. Catalog of the federal domestic assistance. The program is listed in the catalog of federal domestic assistance number 17201. List of subjects in Title 29, Part 29. Apprenticeship agreement compliant with the apprenticeship criteria, the apprenticeship standards, program standards, registration, deregistration, sponsor eligibility, state apprenticeship agency, recognition, derecognition. Signed in Washington, D.C., October 15, 2008, Brent R. O'Rell, Deputy Assistant Secretary, Employment and Training Administration. For reasons stated in the preamble, the Department of Labor provides Title 29 CFR Part 29 to read as follows.